Good morning. Today is Wednesday, March 7th. 2021. I hereby call the Subcommittee on Elections and Campaign Finance to order. Roll call, Madam Secretary.
Representative Holtzclaw, Representative Love, here. Representative Manis, Representative Shaw, here. Representative Williams, here. Representative Wright, here. Chairman Crawford, present. Chairman Rudd,
here.
Chairman Rudd, you have a quorum.
Thank you. We will now begin unless there are any announcements or Representative Shaw.
Thank you, Mr. Chairman. I would like for the committee today to help me make welcomes. We have some special company. Ms. Dawn Harrington and Ms. Keita Haynes are here today to hear our committee, and if you all would help me make them welcome, I would appreciate it very much. Thank you.
And Representative Holtzclaw has joined us. Let's see. We will begin first on item number 1201 by Speaker Sexton has been rolled 1 week. And I believe Representative Whitson is cited under that. Item number 2, 1251 by Representative Faison. That has been taken off notice. Item number 3 by, I think he's a famous attorney from the Middle Tennessee area. There he is, Representative Garrett, 1193. If you, let's see, we have, I believe, there are 2 amendments. Are you just running one?
I'm running amendment ending in 5333, I believe.
That's what we have. We have a motion and a second on the amendment. Is there any discussion on the amendment? Going on the bill. Question? Receive no objections. All those in favor of attaching amendment 5333 to the bill, say aye. Aye. Nay. It goes on the bill. Please tell us about your amended bill.
Thank you, Mr. Chairman and Committee. This bill is brought to me by the Registry of Board and Ethics Commission. Right now, they assess fines. Those fines can only be collected by the Attorney General's office. Some of these fines date back from 2008. What this does and allows the Bureau to hire outside counsel to collect those fines against those that have been properly and duly fined. So with that, Mr. Chairman, I'll be happy to take any questions.
Any questions on the bill? This is, I believe, the same bill basically that went through last year.
That's right, Mr. Chairman. Thank you for making
the House.
Yes, thank you, Mr. Chairman, for making that clarification.
Seeing no questions, is there any objections to calling the question? Seeing none, all those in favor of the amended 1193, say aye. Aye. Opposed, nay. Bill goes on to full local.
Mr. Chairman, thank you very much in committee.
Next on the agenda is item number 4, HB 1157 by Representative Stewart, and that has been taken off notice. Next on the agenda is item number 5, HB 1158 by also by Representative Stewart. That has been requested to roll 1 week with no objections. Rolled 1 week. Item number 6 by Representative Powers, which is HB 1527. He has requested that to be rolled to the first calendar of 2022. With any objections? No objections. That is rolled to the first calendar of 2022. Item number 7 by Representative Hardaway. He is not in the room. That is item number 1324. I'll roll that to the bottom of today's calendar. So any objection? We'll roll that to bottom of today's calendar. Item number 8 is by Representative Towns, HB 1486. He is not present. We'll roll that to the bottom of today's calendar. Item number 9, HB 0561 by Representative Dixie. And he was in the room earlier. Okay, he's on his way back. Roll it to the bottom of today's calendar. Here with today's calendar. Item number 10, HB 0387 by Representative Shaw. Representative Shaw, from your seat.
Can I get a motion?
Motion, second.
Thank you, Mr. Chairman. Thank you so much. I appreciate you giving me the time you've given me on this piece of legislation. And I think I pretty well explained that it was a pilot program just for Nashville alone. And after we talked this morning, I will understand what the concerns are. However, I think I requested from you if you would kind to walk me through basically the committee, what you walked me through earlier this morning about the legislation, because we really do feel strongly about this legislation, but we certainly would want to do it in a manner where it would be comfortable and right for everybody. So could I embark upon you to kind of walk me through the
I will,
committee,
and
what
then,
you did earlier this
then with
morning?
no objections, Representative Love, you after I make a few comments. Also, Director of Elections, Mark Goins, is here. If I get something wrong or don't say something, he can correct us or answer any questions. It's my understanding, number one, we already, what is conducted now in counties, Davidson and other counties, is at election time, the election office goes there, and anyone who's eligible to vote or wants to register to vote, they will register to vote. Anyone who wants to vote, like they do when they visit other facilities like nursing homes and other, they will vote them absentee. And so they're already being voted, and they're already being registered if someone wants to register to vote. What the confusion gets in your bill is it wants the election commission to go around and register everyone. Most of the people in jail are there not for a sentence, but they're there for holding till a trial comes up. And they may be eligible now if they register them now, but in a few weeks or months when they're actually sentenced, they will no longer be eligible because they'll be a convicted felon. So it would complicate the election commission to have to check on all that. Right now it may be one or two. It could be a lot of people that they register that day. Also, it's my understanding that if someone is in, say, the Davidson County Jail, but they live in a neighboring county, they will vote them absentee in that neighboring county, even here. So their needs to vote are met, and to put up an actual voting site there could be somewhat dangerous, plus the machine would be in a non-secure location where the election workers wouldn't control the environment too. But basically everything that you're wanting to do, for the most part, is already being done, and I just didn't see a need for the bill personally. And that was my opinion, what had been expressed to me. Representative Shaw.
Thank you, and of course, I'll certainly give Representative Love an opportunity. I wanted to get that information because those who are in favor of this, I think, have got some ideas maybe that we could come back next year where we could correct some of these issues that you've just pointed out, where it could be a smooth transition. But I do thank you so much for giving us an opportunity to get it on schedule and to talk about it. And after we make all the comments, I'd like to make a motion to just roll it to next year's calendar and hopefully have a better understanding of what we're trying to do, if that would be.
Do that at that time, or I'll, right now, Representative Love, you still have comments.
Yes, sir.
You have the floor.
Thank you, Mr. Chairman. And I did want to ask the sponsor, and I hear your comments, Mr. Chairman. My concern is that there may be people who are actually in the county jail who are waiting on their court date and possibly may be found innocent. And if we register them to vote, it doesn't do any harm to go ahead and register them to vote. If they're found guilty, then they're not allowed to vote. But if they're to be found innocent, they may miss an opportunity to cast a vote. And there may be persons in jail who may be there for, and I'm not sure about this, but I can check with legal, who may be there for misdemeanors. And they're waiting on their court date. And because of our money bail system, sometimes people are just there waiting in jail and don't have the chance to be bonded out. And these are persons who I think would qualify under Representative Shaw's bill to be registered. And then if they either are found guilty of a felony, then of course that registration is voided. But if they're not, we may miss out on people who are unregistered, who either would be there for a misdemeanor or unregistered and may be found innocent of the charge, and now are not going to get the chance to vote because they may miss the deadline for registration simply because we didn't go through the extra step. And I know that there are plenty of instances where people are waiting in jail for a court date And there are instances where you may be arrested, and then the charges are dropped. And sometimes that happens, and people aren't given the chance to expunge the record. But I'm trying to list out several instances where there are people who I think would fit under this category, people who are waiting in county jail, the Davidson County residents, and the disposition of their case may be that they end up being found innocent or that the charges are dropped. And I think there's nothing wrong with giving opportunity, but since Representative Shaw wants to go ahead and roll it, and I think there are also instances where someone may have a felony charge that is reduced to a misdemeanor, and they're eligible to vote, but if we don't take the chance to register them to vote, we miss that. But again, I just want to put that on the record that there are opportunities like that we miss out on, but I do respect Representative Shaw's request to roll it, but I did want to get that on the record that we do have persons who may fit in that category.
Thank you, Representative Love. I think also it'd be pointed out as far as information for the sponsor to consider when he formulates and look this over. People still that if it's within the time limit, they can still register to vote. It's no harm for someone asking to vote. I think the concern is just the requirement in the legislation to require election workers to go around and ask everyone to vote, when that may take up a lot of time and be dangerous to add too many people and too much of a burden to them to keep up track with who's found innocent or guilty or their charges reduced. Also, there's nothing right now preventing anyone can go to the election office and pick up voter registration forms. The jail can always put those out and handle that themselves internally if they wish, but to require election workers to do it may be a burden and somewhat dangerous. The sponsor, Shaw, and then Chairman Crawford.
Thank you, Mr. Chairman. Just two things, that this would only be a pilot for Davidson County. I want to clear it up. And secondly, I'd like to request your help, maybe, and we look over some things at some point in time, if you'd meet with us and we could sit down and talk about some things that maybe.
I'm always willing to help anyone.
Thank you so much. I appreciate that. And with that, I'll make that motion to
Well,
move.
he's
Okay.
on. Before you do that, Representative Chairman
Okay.
Crawford had asked to say something.
Yeah, Mr. Chairman, and correct me if I'm wrong, sir, but I believe under federal law, we have to provide that information to the jails now, as far as registration forms and all that. So that information is already there for them, as Representative Love was talking about. That information's already there. We already do that anyway. So that would be a duplication of service. Thank you, sir.
Any further statements? If not, I hand it back to the sponsor of the bill.
Thank you, sir. I'd like to make a motion to move this to first calendar of next year.
Of 2022.
Yes.
Here a second. Any objections or discussion? Seeing none, all those in favor say aye.
Aye.
Opposed, nay. Bill is moved to 2022, first calendar of committee. That is 0387. Next is to go back to item 9. Representative Dixie, 0561. You have the floor. We have a motion and second.
Thank you. This legislation eliminates the complex and confusing administrative process currently required to restore voting rights after a felony conviction, except those convicted of murder or a felony sexual offense. Upon completing all of the terms of their sentences, including prison, parole, and probation, and provides a steady temporary suspension of voting rights until the sentence is complete, with automatic restoration of voting rights upon proof of completion of the sentence. Over 450,000 Tennesseans, almost 1 in 10, cannot vote due to a felony conviction. Tennessee's system for restoring voting rights is unnecessarily complex and does not work. Since 2016, Tennessee has only restored voting rights of 3,415 people. A lawsuit filed in December of 2020 is challenging Tennessee's laws. Now, Tennessee's overall disenfranchisement rate is the second highest in the country. Tennessee is the only one of 11 states that disenfranchise felons at all levels: prison, probation, parole, and post-sentence. 2 states and District of Columbia do not restrict voting rights at all, even while in prison. Tennessee is the only state that requires child support to be current for restoration. The problems this bill addresses: a felony conviction permanently removes the rights in Tennessee. Some can apply to have their rights restored, but it depends on when they were convicted, what they were convicted of, whether they have completed probation or parole, whether they have paid all courts costs and restitution, and whether they are current on child support. How this bill will address those problems. It automatically restores voting rights after completion of the full sentence, eliminates financial obstacles, eliminates complex administrative process in restoring rights, addresses issues raised in federal court, and save taxpayers hundreds of thousands of dollars by reducing recidivism and incarceration costs. And it'll save on administration costs as well. Tennessee released over 6,100 felons in 2019 and year 20. Approximately half of those released in Tennessee reoffend and are reincarcerated within 3 years. When voter rights are restored, the research in Florida showed the recidivism rate dropped 12.8%. In Tennessee, that would be 795 fewer people incarcerated each year. Right now, Tennessee Department of Correction cost to house one inmate for a year is $31,000. That would potential savings to taxpayers would be over $24 million each year. So this is a cost-saving measure, but it also allows people to get back, re-enter society, and be a productive member of society. I think that this bill addresses all those issues, and I ask you to consider that moving this to full.
Chairman Crawford.
Thank you, Mr. Chairman. Just for clarification, I want to make sure I understand correctly. You're saying your bill would allow their voting rights to be restored even though they have not completed court cost and even if they owed back child support, correct?
Yes, as soon as they complete
Thank you, sir. Thank you, Mr. Chairman.
Yes, Representative Dixie.
Yes, as soon as they complete their sentence, their physical sentence, then their rights should be restored.
I believe this would also, does your bill, even if it's a part of a judge's sentence, it overrules the judge's sentence?
I don't understand.
In other words, if a judge rules someone to go to prison and they're not to have these rights restored, under your bill, they would be restored even though it was a part of sentencing.
No, they would have to complete their sentence. And once they complete their sentence, regardless of, they would have to complete their sentence, whether it's probation, parole, or incarceration.
No, I'm not talking about that. I'm talking about if the judge, let's say they sent them to, 5 years in prison.
Correct.
And a part of the sentencing was that they were not to have their rights restored to vote unless they had paid back court costs or child support or whatever. This would overrule a judge's decision, wouldn't it, on that particular thing?
Yes, but I don't think I've ever seen a situation where a judge puts that particular restriction on a jail sentence.
Okay. Is there any further questions? Representative Manis.
Thank you, Chairman. I guess the question I have is, this is about voting rights, and it's just a question of clarification. So if you have not been incarcerated and you owe back child support, you still have voting rights, right? If you haven't been incarcerated. So if you owe back child support, you do not have voting rights, even if you've never gone through incarceration.
Yes, Representative Dixie.
In Tennessee, if you owe back child support, you cannot vote.
Okay. Period.
Period.
Okay.
You informed me. I didn't know that without a conviction.
Am I correct? Am I right?
That legal said yes. Hold it.
Okay.
Hold it.
Tell me.
We might need to go out of session. We're getting conflicted. Mark Goins is here. If you want him to go out of session, he can answer any questions. Any objection? We'll go out of session. Let Director of Elections speak. We are out of session.
Since they wipe off everything.
No. So Mark Goins, Coordinator of Elections. So in 2006, former Congressman Cohen and a former state representative named Representative Turner, they brought legislation forward, and the law specifically only applied to folks who had committed a felony. So under the Constitution, if you commit, in the Tennessee Constitution, if you commit a felony, then you can lose your rights to vote if the General Assembly agrees to do so. They have the authority to set that process. So in 2006, the legislature, with the legislation that former Congressman Cohen sponsored, chose to do that. So they said if someone is delinquent on their child support, then they could not get their rights restored because the Constitution allowed that voting right to be taken away. If you are a person that has never been convicted of a felony, then you do not lose your right to vote. So that is what the distinction is. So if I am someone who is behind on child support, I'm still eligible to vote. But once I'm convicted of a felony, Tennessee law and the Constitution of Tennessee allows, you basically forfeit your right, if you will. And so at that point, so in 2006, the child support provision was added. Later on, we had a provision that said if you had not paid your victim restoration, you couldn't get your rights restored. And then the other thing is court costs. It's already been mentioned. So what Representative Dixie is seeking to do, at least one of the things, there's some other things too, but the main thing is if this were to pass, the requirement to be up to date on child support, to paid victim restitution, and to paid your court cost would go away. So even if you owed any of those three things, you would be able to get your rights restored to vote. If you've not convicted of a felony, none of those things apply because you've never forfeited your right to vote. Hope that understands it. I hope that explains it. Yeah.
Representative Hosquall.
Thank you, Chairman. How detailed is our software to keep track of all this and that kind of stuff?
So that is one of the issues that potentially, if this were to pass, so this would be a suspension. So currently the process is we purge someone if they've been convicted of a felony. And in other instances, we don't register a person if they've been convicted of a felony because they've checked the yes box unless they supply a certificate of restoration. It's that certificate of restoration that allows us to know what crime they've been convicted of in many instances. It also allows us to know if they're caught up on various court costs and victim restitution, and then we check on child support instantly. The issue that we potentially would have if you're convicted of another state in another state, or even some instances in Tennessee, we wouldn't necessarily know what that conviction was without further follow-up sometimes from the individual. And there's certain crimes in Tennessee, voter fraud's one. If you, in your official capacity as a government agent, commit some type of crime in your official capacity, you are forever forbidden from registering to vote. No matter what, you can't do it. And this bill, as I read it, doesn't change that. If you're a murderer, if you're a sexual predator.
Right.
But we are in elections. We're not criminal, in the criminal sphere as far as probation and those things. So we don't have necessarily those records, and certainly don't have them from other states. We do work with TDOT, the Tennessee Department of Corrections, and we get some of their information, but it would be very difficult to figure out who is permanently disqualified and who's not. So that would be one of the issues that you would have. The other thing is, it's a suspension. So someone's going to commit a crime, and then we're going to restore them back. We're going to have to keep this information separate. I'm not exactly sure how we're going to keep up with who is now out of prison and who's in.
Well, wouldn't that be the responsibility of the person to come and notify you or bring that document to you?
That'd be correct. I think we would have to come up with some process that maybe not outlined in this legislation. Administratively, we would have to figure out some way to do so. But there would be some administrative challenges to do so. A simpler way, if the will of this body is to do this, the simpler way to do it is just say child support, victim restitution, and court cost is no longer a requirement to get your rights restored, but still keep the certificate of restoration. That way we would still have notice of what crime you committed.
Representative Shaw? Oh, you, Pam? Okay, Representative Love, I had Shaw then.
Thank you. And let me ask yourself, Director Goins, and sort of a follow-up on Representative Manis's question. So currently, you can be behind on child support, and as long as you have not been convicted of a felony, it does not trigger you being unable to vote. But the moment that it does, even if you serve your entire sentence and pay all your court costs, but are still behind on child support, you still can't vote.
That's correct, because the legislature has said if you're convicted of a felony, you've lost your right. So it's gone.
Okay.
Now it's a situation where you're getting that right back. You know, if the legislature wanted to, they could come in and say, if you commit a felony, you never get your right back. And in fact, have done so, you know, in certain instances. If I've never been convicted of a felony, there's no authorization for this General Assembly to say I can never vote again. That would be unconstitutional if you were to say someone has never forfeited their right to vote if you put additional qualifications on it. So this is a situation where this individual has lost their rights, and that's the only reason. So this has been litigated. Right. This issue very specifically, child support, was litigated shortly after that law passed in 2006, and because the court looked at the fact you'd lost your right.
Sure. And if I could, Mr. Chairman, a follow-up. If I could follow up, please. Yeah. Also, let me ask you this. Is it any kind of court costs or just court costs related to that particular crime that violates prevents me from voting?
So if it's a court cost that's related to a misdemeanor, it would not be part of this, but any court cost that is associated with a specific felony that caused you to lose your right to vote, that's the court cost that you have to be up on.
Okay. And if I'm not mistaken, okay, thank you.
Representative Crawford.
Representative Crawford?
Thank you, Mr. Chairman. I think my question was asked by Chairman Holtzclaw. I got my answer.
All right, Representative Manis.
Thank you, Mr. Chair. If you'll bear with me, I think I'm the only freshman on this committee, so I will ask the ridiculous questions. But I guess let me just say this. I am a huge proponent of people paying their child support. So I just want to get that on the record. People should pay their child support. But I'm also a huge proponent of reestablishing rights and working toward lowering the recidivism rate when people have served their time. And so if I haven't committed a felony and I haven't been incarcerated, then my voting rights, if I choose not to pay my child support, then my voting rights, I still have those voting rights. I struggle, I guess, then if someone has served their time and we're trying to get them hopefully back on a path, their ability to vote or not vote now is tied to paying court costs, paying child support, and these other things. I'm struggling to see the equity or the fairness in that. And again, being a freshman, I'm trying to get my arms around it. But that's my point, and I don't know if there's any further clarification to that or not. So,
well, you know, as I said, this was passed prior to me even becoming coordinator. I mean, it's 2006, and so I'm sure that was an issue that was heavily debated at the time, and you know, that was a discussion that was taken at that point. But I do want to clarify, it's not just child support, it is court costs, it's also victim restitution. Victim restitution, child and court costs was added later. That was not added in 2006.
Representative Williams.
Thank you. I guess the question I have for you, Mr. Goins, is I think you made a statement a moment ago that I think is really the determining factor for me, and you stated, and I just want to clarify, you stated that this is a reestablishment of a right. These rights were stricken. So to challenge, to argue that this is comparable to something else as it relates has, by nature of the definition, say that they're completely unrelated, in that these people lost their right to vote. There are certain boxes which have to be checked because of that crime, and until those boxes are checked, they're doing it. But to say that one was lost or not was lost based upon any other matrix would not be comparable. Am I missing something?
Yeah, I think another way to explain it, as a policy, it could be that the General Assembly said, we would prefer that if you're not current on child support, you would not be able to vote. However, you don't have the constitutional authority to do that because someone's not lost their right to vote, unless you said being delinquent on child support is a felony. And so you're correct. I mean, you couldn't, under what Representative McManus is saying, it may be that the policy level would be, we want people to pay their child support, so we would require this, but you're not able to do so.
Yeah.
It is a restoration of right. It is not a it's not a forfeiture of right in this realm of folks, right?
Furthermore, because of the criminal activity and the prosecution and conviction of the crime, part of that is not just the jail sentence, it's also these other parameters that the legislature saw back then to codify. Is that not right?
That's correct. So I was here in 2009 when the court costs came in, and that was actually something that the clerks, it wasn't something that came from the Secretary of State's office. What I remember, the clerks actually had asked the legislature to come in and do that. So you're correct. It's the General Assembly that has put the pieces of the puzzle together, making policy decisions.
Thank you.
Representative Shaw. Oh, okay. Is there any further questions of Director Goins? Seeing none, we thank you. We'll be going back into session. Representative Dixie. All right, now we have Representative Shaw, if you wish to.
I think it's important that it's important for me to put this on record. I do think that when we look at voting rights, it's a broad spectrum of issues that we're either depressing or we're helping. If we're going to get people back qualified to work and even to pay their child support and all of these issues, we got to look at the broad spectrum of things, in that a man who is not working can't pay child support. A man who is not qualified to vote is cut short of so many opportunities to be successful in his life, to do what he needs to do. So I think if we're one of those states, and we are, who believe in right to work and people have jobs and do well, I do think that's an issue that we got to revisit in some way or the other, because I believe that that is really a big holdback, if you will, on a lot of opportunities for people across the state of Tennessee. And I just think I'm a man of a second chance. You know, I guess the reason I'm a man of a second chance is because good Lord gives me one every morning. When I get up, I don't deserve to get up, but he gives me new mercy to operate on every day. And I mean, that's just my feelings, that this is something that I think we really, and I don't think we ought to violate any laws or do anything wrong, but I do think it's something we ought to give a hard look at as to how we can re-overhaul our system to make it better for these people who deserve a second chance. And thank you, Mr. Sponsor.
Representative Dixie.
Yeah, thank you, Representative Shaw. But I want to address Representative Holtzclaw comment about, and maybe help Mr. Goins here, is that when they have their reentry plan, when they get their red date, when they get ready to get released, they have a hearing, they get a docket, they get to go over all this stuff, and they should go over this stuff a year ahead of time. So in order for them to know who was convicted, who's eligible during that time when they're getting their reentry plan together, that's the time for them to do this. But I also, Mr. Chairman, I'd like to request a roll call vote.
Okay. Representative Williams, were you next?
Thank you. Representative, I appreciate your comments and your passion about this topic. And Representative from on my committee, I too am a man of second chances. Matter of fact, I'd say I'm a 70 times 7 kind of guy, maybe not just second. But I will say that this kind of, I think we kind of get lost in the weeds here. We can forgive somebody even in the midst of their incarceration if they've done something. The issue here is, do we want to change the way that the process by which someone who's convicted of crime, do we want to change the way that future legislatures have determined whether or not these are the certain parameters you have to meet in order to regain your opportunity to vote? I recognize that people have child support concerns. I've volunteered with men in the local sheriff's office who are delinquent on their child support as well, and had this discussion quite often, to be honest. And so my concern is that it's a rush to say that we have to give this back to them sooner just because they already paid their debt. But a part of the debt of the crime that they committed is this restitution. So you can get if you were, for some reason, missed this election, no one's to say you can't get those rights back by the next election, which is why the legislature codified this opportunity to do that. And so it may be that they missed that, but because they have to pay the restitution as far as court costs are concerned. But I can appreciate your concern. I think that I believe that the legislature prior to us determined that these things were important as it relates to restoring someone's right to vote. And I'm going to vote to preserve what they've done in the past. Thank you.
I'll take 1 moment. Representative Dixie.
Oh, I was like,
respond.
thank you for your comments, but I just want to reiterate, Tennessee is only one of 11 states that takes away this right at all levels, whether it's prison, probation, parole, or post-sentence. So the same way that we took it away, that doesn't make it right. At some point, it is never too late to do the right thing. And I think that getting people a chance to get to re-enter society and be a productive member and becoming an asset by making them feel just this small thing of voting, that a lot of our people that look like me, died for this right. People have fought for this right. And I think that it was taken away arbitrarily. I don't know why it was in the past, but after 11 states, only one of 11 states do this. So there's a lot of other states that didn't feel need to take away someone's citizenship just because they committed a felony crime.
Representative Williams.
Multiple things. One, no one's taken away their citizenship. Two, no one's taken away their right to vote. The moment they committed the crime, they rendered their right to vote, and that their right to vote was rendered upon conviction. That's the facts. No one's taking it away. Their decision, the repercussions of their decisions to commit a crime caused them to be in this predicament. There is a way out. The legislature and I support the way out. That's the difference. Thank you.
I'll Representative Dixie. Any follow-up? Or?
Yeah. I understand your position, but I disagree. I respectfully disagree. It was taken away. Their right is taken away because there's a path to get it back. After it's very hard to get it back. If it was easy to get back, it would already have been done. We have a duty. We have a duty in this legislature to help people get involved in the democratic process. That's why we're all here. That's why we are here, to make it a better place for all Tennesseans. And just because someone commits a crime doesn't take that duty away from us.
I'll take a moment of personal privilege. There's one thing, and I've always been a big advocate of people once they've served their time, they should be allowed back into all their rights restored, unless it's a very heinous crime, which your bill takes care of that mostly. Of course, if they do these things and pay restitution, they can resume. But the one issue, you can argue court costs or even child support, but victims restoration, when a person has violated someone's rights and harmed another person that they had to go to prison for, and then to say when they get out of prison that they don't have to pay the victim back the restitution, that's almost like we're cutting their sentence short, or like it's almost an insult to the victims that they don't, the victims restoration, it seems like that should be a priority, that's real that's almost like a part of their sentencing. It's almost like letting them vote while they're in prison because they haven't paid the victim back. So that's the one part of your bill that really sticks with me is about the victim restoration. If you have anything follow-up, if not, there's, I think, 2 or 3 others. I believe next on the list is Representative Love.
Thank you, Mr. Chairman, and to my colleagues, I do want to remind them that child support accrual does not stop when you go into prison. Yet, oftentimes, your earning capacity tremendously drops. And current state law doesn't make any provisions for adjusting the amount owed. So I'm owing $500 a week for child support, or $500 a month child support in April of 2021. I go to prison in June 2021. For 5 years, I have $500 a month accruing on my back child support, and my earning capacity in prison is going to be no more than maybe a few dollars a day. So for me, the issue then becomes, which is beyond the scope of this committee's work when it comes to that piece, but there's an issue where we must realize that there are people who are now going to have a huge amount of child support owed when they come out of prison, and they could pay all their court costs and still have a huge amount of child support left to pay. And we don't even make provisions to allow them to start paying on it and have good faith effort toward it. A few years back, we passed legislation, actually, members, that allowed us, that allowed men or women who owed child support, rather, to make a payment arrangement with the mother. And that cleared it up. But we did not allow them to make a payment arrangement with the state. And so we had a duality right there, a dual system for people. And again, Tennessee is the only state that has this requirement, and it allows it to accrue. I hear the angst and the heartburn. I would ask this of our members, and I'm trying not to speak for Representative Dixie or Chairman Dixie, but maybe he'll go along with this. If we can agree to get it to full, oh, don't shake your head already, Chairman. I hadn't even finished my sentence. No, oh, Cloud. I was going to say he's going to buy us all dinner, but you shook your head already. See? All right. Get it to full and work on this, and maybe it becomes the victim's rights or restoration piece stays in that you got to pay. Maybe court costs you got to pay, but the child support piece is what becomes the linchpin for voter restoration. Now, this is a suggestion, because we have the power to get it to full and hold it there while he works on it. That's a suggestion. Yeah, linchpin.
Representative Wright, you were next on the list.
Do you have more? Thank you, Mr. Chairman. Do you have more of a list?
2 more. As of right now, 2 more.
Okay, I'm going to say thank you, Representative Manus, for you being a freshman. That pushed me up to being a sophomore. Next, I'd like to pat the sponsor on the back I applaud you for working your bill. You and I had an in-depth, lengthy discussion of where we each reside on the question that's before us. Something I did not say the other day, that I know the path to restoration is complex, because I've worked with a couple of guys that have not been restored yet. So I know it to be a complex deal. And one of the things that plays into this, the child support, for example, I'm just using just that one point, child support. Maybe there's some way of crafting a bill that would address that one issue, and if there is a child support plan, that maybe it then becomes not so much as an issue as it has been today. I look at the estimated physical impact, saying it's not significant, but that impact statement has 14 points in it. And the director has just testified that he doesn't know what it's going to cost to have a list or run the data or have things in place just to support whether or not we're suspended. And then we go to the What's it going to cost us to send folk to the facilities and do voter restoration or registration? That's like two different issues in itself. And as I said, there are 14 points on this particular not significant impact statement. I believe there are too many issues in this one bill for it to be held over to next spring when it needs to be several divided questions. And I'm pressing myself now. You said you had a couple other speakers. It may be that what I'm about to say may not get anywhere, but I think it's time to call a previous question.
We,
Move previous question if I want to use.
Rules don't allow you to move previous question because you comment on.
Okay.
we have Representative Holtzclaw next, and,
Okay.
Dixie, excuse me, Representative Dixie.
I'm saying, can I respond? Right now, currently, we take away their voter right very easily. With one suit, it takes one step to take it away. But in order to get it back, it takes all these steps to get it back. That inherently says there's something wrong with the system. And it's up to us to fix it. And I'm asking you to help me fix it. I think that there are some, I'm not saying this is a perfect bill, and I agree with Representative Love. It does need some work, and I think that we can get there if we work together to do this. And so I would ask that we could move it to the full where we can park it and have some time to work over it over the summer. That would be my ask of the committee, because I think that this is a really good bill. I think it sparked some good conversation. And actually, Representative Wright, I think that there is a bill that's out there that is going to, I think it's going to suspend the payments out there while they're in jail. I don't know. I think it reduces it, but I think there's a bill out there. I haven't seen it yet, but I think there is one out there that will address that. But if not, maybe that's something that we can address in this bill. So I would love to continue to work on this and get it there, park it. I say it's not a perfect bill, but it's a start. And we all need a start somewhere.
Representative Holtzclaw, you're next.
I'm going to yield my time to Representative Williams.
Representative Dixie, I appreciate the fact that you're very passionate about this, and I'm going to say this again, just because you keep saying it again. But when you commit a crime and you're convicted of that crime, no one's taking it away. You forfeited that right. And it concerns me a little bit that you say you want to work with us, and yet we can't even agree on that simple component of the bill. But because I love you, and you sat beside me on the House floor for a while, I think we as a body have been directed not to move bills to be worked on. But if this is something that you're very passionate about, if we, instead of just killing it now, you could take control of it, take your bill off notice. I'm sure based upon the communication here, there's at least 3 of us that would love to talk to you about it and see if there's something we could come up based upon the caption that you got and see if there's something there. But I think that's probably your best bet at this point, because I can't support moving it to full committee knowing that I feel like that we're not even halfway there. But I appreciate it. Thank you.
Representative Manish, you were next on the list.
Thank you, Mr. Chair. I guess I have just a couple of things, and I'll echo what Chairman Williams said. It's not taking away. You know, I really want to support this legislation. I really do, but they forfeited their voting right. In my opinion, it's about restoring their voting rights with these conditions. That's the way I'm trying to process it. And I struggle also with if the victim restitution was not kind of one of the conditions that we wanted to do away with. If you had not committed a felony, you would not have victim restitution, correct? I mean, so that in my mind is tied directly to committing the felony. So again, I'll say I'm with Chairman Rudd. I mean, I really do want to support it, but I struggle with the victim restitution part being taken out. So that's my feedback. But thank you.
Representative Dixie.
And I would ask, and I know there's a list, but I would ask any of you, if you know of a crime that's a felony that someone's serving time on, where they would have to pay victim restitution.
Are there any further questions?
Can anyone answer that question? Is there a felony that someone's in prison serving time for that victim restoration comes into play, where they have to pay victim restitution?
I
'Cause
guess
the reason
I'm
why-
struggling to understand. I think a lot of cases, I'm struggling to understand your question. I think a lot of cases, if victim restoration, let's just say that, I don't know, let's say somebody stole, I don't know, let's say they stole money, embezzled money, or they stole a car and wrecked it, and the family can't afford to replace it, and they're actually have a monetary loss. And when they get out of prison, they're to get a job and try to repay that money, and then their rights would be restored. That's the way I view victim restitution. And that's really a part of making the victim whole.
And that's where I would disagree with you. But I think that when you go to prison, that is you paying your debt. And I highly doubt. I wish we had someone from the criminal or the legal in here that could answer this, because I cannot think of an instance where restitution occurs when you go to prison. Most cases when a victim owes restitution is for misdemeanor offenses. Like you said, if you stole something, if you vandalized something, things of that nature. I've yet to see something in prison where someone owes victim restitution. And I just think that language may be questionable that's in this bill.
Are there any further questions? If not, the sponsors requested a roll call.
So this is.
Oh, excuse me.
If I will I would like to make one last statement, and thank you, Representative Williams, for your comments, and I appreciate working together, and I appreciate you giving me the benefit of the doubt, because we sat beside each other and we have fashionable glasses, and that I copied you on. So I would like to take your recommendation, and if I could just roll it to the next available calendar next year, the first available calendar next year, I think that would probably be that would give us time.
Representative Williams.
I'm amenable to that. I just want to make sure that you're not impugned by your suggestion. The House rules changed this year as it relates to bills, and my fear, I just want to confirm based upon the House rules, whether he should do that or he should take it off notice in this posture here, and then he can put it on notice next year. Because I think that the way the calendar works, I think it could be that you'd lose this bill and you'd have to use one of your 15 next year to refile exactly the same bill. And so I just want to make sure you're covered.
Okay. I would like to take it off notice.
All right, Representative Dixie, the sponsor, has requested HB 0561 to be taken off notice. Any objections? Seeing none, it is taken off notice. Next up is, I believe, Representative Hardaway is in the building. Item number 7, HB 1324. Hear a motion, hear a second. Let's hear about your bill. And I believe it is traveling with an amendment, or has an amendment. Could you tell us your reference number of your amendment?
Yes, sir. The amendment that you have, for the purposes of adding that amendment, which will rewrite the bill, I'd like to go ahead and put that on now, Mr. Chairman.
Is that, we have 4477, is that correct?
Yes, sir.
Here, motion and a second on the amendment. Do you have any objections to applying the amendment? Seeing none, all those in favor say aye. Aye. The amendment is attached to the bill, 1324. Let's hear your amended bill.
Thank you, Mr. Chairman. And it's a simple bill with the amendment that rewrites it. The Secretary of State will conduct a study on the use of student IDs from the higher ed public institutions, and he will report back to the General Assembly. Very simple, very
Do I hear any questions
cut.
on the bill? I have, well, excuse me, I'm in questions. Before we had Representative Williams hold his hand up.
Representative, I don't have a problem with this premise, but did the Secretary of State agree to do this study? I guess if we pass a bill and tell him to do, I mean, is he going to be is he actually going to study it, or do you know?
Representative Hardaway.
He is, sir.
So,
I'll go, Representative Williams.
so there won't be any cost of him to do the study. He's just going to do it with his own sources.
Representative Hardaway.
Yes, sir. The existing resources within his department.
Thank you very much.
Any further questions? We have a question on the bill. I have, seeing no objections, all those in favor, vote aye. Aye. Opposed, nay? Nay. Nay. Bill fails for lack of noes carry. Sorry.
Thank you, Mr. Chairman.
Is that?
I'm surprised, but thank you.
We had had a request on HB 1486 by Representative Towns to take that off notice, but this is the third calendar, and according to the rules, we have to move that to the special calendar, which will be heard next week with the final calendar. And one more item to clean up here. Let's see which. We need on item number 4, HB 1157, which was taken off notice. We need to have a motion to reconsider our actions. Have a motion. Second. Second. What we're doing here is we took that off notice, but that is the third calendar. We have to do the same thing there according to the House rules. We need to send that to the special calendar of the final calendar next week. So moved. So moved. Second. With second, all those in favor say aye. Aye. Opposed, nay. Ayes have it. And I believe that concludes our business today. Thank you all for coming. We will see you next week for the final calendar. Thank you.